contested decree, but you say you are not served.
I am not certain. Third party, one Supriya Ghosh. This is the signature of Supriya Ghosh. She appeared in the said suit. She appeared for 2 or 3 occasions. Thereafter, due to non-taking of any stage, suit was posted in the ex parte board and suit decreed ex parte. It is against the ex parte decree of divorce. In connection with 125 proceedings, in course of hearing, they produced it, the certified copy of the ex parte decree.
So you learned from there. You learned from there for the first time.
Yes, for the first time, on 28th March 2023.
And when did you file the appeal?
I applied for certified copy and I filed the appeal in May.
Yes, you are condoning the delay.
May I? My lord, I have already filed a opposition to the condonation of delay application.
You have?
Thereafter, yes, my lord, thereafter.
No, we don't find any opposition here.
Yes,
Opposition কোথায়? দেখুন তো opposition কোথায়?
My lord, last occasion while this matter was taken up, your lordship wanted, after hearing my learned friend, that his core argument is that.
Take the mic a bit closer.
My lord, the person who had,
Thank you.
the lady who had been represented before the learned court below was not his client. So the wakalatnama which was submitted before the learned court below, that is of one Sujata Ghosh instead of Sujata Kaur. Sorry, my lord, I'm taking Supriya Ghosh instead of Supriya Kaur.
Sujata.
Yes. Now, after hearing that argument, your lordship wanted to see the wakalatnama. Last occasion, he filed it by way of a supplementary affidavit, the certified copy of the wakalatnama, and your lordship granted me liberty to file opposition to such supplementary affidavit, which is here.
And this is the reply.
Reply has been served upon me today outside the court. My lord.
Today.
Yes. My lord, if your lordship is dealing with the section 5 application only, then I will not get into the merit with regard to the wakalatnama and all. My lord, in the section 5 application, there is no mention of the day from which the delay is being computed.
According to you, what will be the delay?
My lord,
143 days we are lenient.
Right.
So let us allow the section 5.
Right.
And then immediately after that, the supplementary affidavit was in respect of that stay application. We'll come to that. Let us just allow this application. Immediately after that, we'll take up stay.
Not stay application. That is in connection with section 5 application.
No. Supplementary affidavit was
Can number 1.
Can 1 is the section 5.
Yes.
Can 2 is the stay. Affidavit in opposition, reply all in respect of 2. All in handed over the opposition and the reply.
Today is the opposition with regard to the supplementary affidavit and reply has
Oh,
been
this is in respect of Can 1.
Can 1. The condonation of delay.
It is in connection with we filed application, supplementary affidavit in connection with 1.
Achha, let us find out the supplementary.
This is my name, my lord, and the suit was filed against this person. Kindly have a look at the certified copy. I have filed supplementary affidavit wherein it appears that one Supriya Ghosh.
Contested decree, but you say you are not served.
I am not certain. Third party, one Supriya Ghosh. This is the signature of Supriya Ghosh. She appeared in the said suit. She appeared for 2 or 3 occasions. Thereafter, due to non-taking of any stage, suit was posted in the ex parte board and suit decreed ex parte.
But how is it relevant for Can 1?
That's why.
Can 1 is only the reason because you knew for the first time.
This is
Even if you are the Supriya Ghosh aspect was not there, then also you knew for the first time because when the suit was decreed, you were not present. It's either Supriya or you. So in any event, you can take this defense that for the section 5. Yes.
In the appeal,
This is a very relevant factor in the appeal and the stay. So we'll treat this as supplementary affidavit to Can 2. He is asking for Can 1 to be allowed and you are opposing. Can 1 ta shudhu age dichi. Upon perusing the application, the affidavit in opposition and the affidavit in reply, we are convinced of the sufficiency of the cause shown by the appellant for the delay in preferring the appeal. Full stop. The decree was an ex parte decree, and the appellant pleads that only upon coming to know of the said decree in a proceeding between the parties under section 125 of the Code of Criminal Procedure, comma, the appellant became aware of the ex parte decree and took steps, comma, causing the delay. Full stop. Upon hearing learned counsel, comma, can 1 of 2023 is allowed on contest, thereby condoning the delay in preferring FAT 150 of 2024. Full stop. The appeal is deemed to stand registered and admitted. Full stop. Now move can 2. Can 2, this will be germane for can 2 and can 3 also. Stay and injunction. Stay we don't generally grant because it's a sort of judgment in rem. But injunction, restraining, have you remarried in the meantime?
No.
And I have.
So what about this? What about your argument on this? This will be but Mr. Haldar, if you want to rely on this, these are a part of the record then. This is a part of the record. So we can hear this in appeal. This aspect of the matter at the stay or injunction stage, there is no use because in any event, if the appeal is admitted, which is automatic, so we'll grant injunction and we'll record these supplementary affidavit and your opposition. What is your opposition to this?
My lord, can 3 I have been served today morning itself.
Can 3 is an injunction application.
Yes, my lord. Since your lordship was saying.
No, but what is your defense to the Supreme Court?
Right, my lord. My lord, may I?
Just tell us. I
Yes,
mean, we won't
in
go into
short,
the.
I will take only 1 minute. My lord, the appellant herein is a practitioner, legal practitioner in that court itself. Number
Acha.
one.
Acha.
Number two, my lord, in the event someone tries to, the allegation has been leveled against the advocates also, representing the husband therein. That day, in connivance with others, this particular wakalatnama had been submitted.
But she is a practitioner. Husband is not.
Not. And my lord, if somebody.
So you say the records might have been manipulated.
That is a ground in our opposition. And my lord, apart from that, in the event somebody, that is a normal course of action of a person. Well, in the event somebody wants to impersonate some other person by way of some other person.
Would not sign in a different name.
And my lord, the learned judge was dealing with the matter for quite a long time.
All right, we'll consider this.
Maharaj,
We'll keep all these open for being
Yes.
decided in the appeal.
In 2009, Maharaj, I was married to the opposite party. Thereafter, Maharaj, I went to Durgapur. Initially, my lord, prior to my marriage, my lord, I
Won't
was-
go into those at this stage.
And my lord, the maintenance case under 125 and the domestic violence case, both are pending with the same court. She
No,
is
no.
contesting.
no,
This will be considered.
it is in Howrah court. Maharaj, it is a
No,
Howrah
if it is a order for 27 scenario, we would consider.
And they also.
But
never-
here there is the question of new document coming in
And-
because whatever they say is already on record and your defense will be.
And also they did not approach the same court that see these things have happened. So
We'll do this.
Yes.
We'll keep can 2 of 2023 along with the opposition reply and the supplementary affidavit for being heard along with the appeal.
Right.
So that these documents and your opposition to that can be considered by us.
Fine.
We'll do that because this is the new ground taken in the appeal. And injunction, we are injunction. Just take a look and
I've read it already.
we'll say that you are not admitting any of the allegations made.
Right.
যেটা বললাম তাই তারপরে can 3 of 2025 is an application for injunction restraining the respondent husband from remarrying till disposal of the appeal. Push up, since the present suit has been preferred against a divorce decree, comma, unless the injunction prayed for is granted, comma, the appeal itself would be rendered infructuous. Push up, accordingly, can 3 of 2025 is allowed, comma, thereby restraining the respondent husband from contracting any remarriage during the pendency of the appeal. Push up, next para. Can 2 of 2023 is an application for stay. Push up, although otherwise in view of grant of injunction, comma, the said application would lose relevance, comma, in view of the allegations and counter allegations made in connection with the said application, comma, particularly in the supplementary affidavit filed by the petitioner and the opposition and reply thereto filed by the parties, comma, where a serious allegation has been leveled by the appellant as to the appellant having been impersonated by someone else before the trial court, comma, which is squarely controverted by the respondent, comma, we are of the opinion that the said application along with the connected pleadings thereto should be heard along with the appeal. Full stop. This is all the more so since the allegations and counter allegations leveled in the pleadings made in connection with Can 2 of 2023 have a direct bearing on the outcome of the appeal itself. Full stop. Accordingly, Can 2 of 2023 shall be listed for hearing along with the appeal itself. Full stop. Next para. In view of appearance of the respondent through his learned advocate, service of notice of the appeal is dispensed with. Full stop. There was no previous direction for paper book. Next para. The trial court record shall be called for by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks.